Thank you everyone for coming tonight. It's such a beautiful spring night. I'm really glad to see such a nice audience tonight. My name is Jenny Lukomsky. I'm the archivist for the Sisters of St. Agnes. So in 1976, when this country was celebrating its bicentennial, I was 5 years old. And so I still remember the pageantry and the excitement and just the pride at our country having reached this milestone. And so now that the semi-quincentennial has approached, I knew I wanted to do something. And being an archivist, I'm in a position to do that. So, of course, the Sisters of St. Agnes also wanted to share in this celebration of our country. So the Committee of Sisters and I pondered what it means to be an American today. Working for a religious congregation, I always hear about the call. So what is the call to the United States, we wondered. And we settled on these words from the very first line of the preamble to the Constitution: to form a more perfect union. That call, our call today, remains the same as the one heard 250 years ago. So has the United States ever been a perfect union? Of course not. So in fact, 50 years ago, when I was eagerly anticipating the celebrations of the bicentennial, our country was struggling with a lot of similar issues that we're facing today. And even back in the mid-19th century, Alexis de Tocqueville wrote Democracy in America, and he noted all the contradictions and paradoxes in our country, but he also noted the hope that the people had. And that's what we're celebrating this year, the hope that we and our ancestors have had for 250 years, that we can live up to the values that have been put forth in our founding documents. So we've put together this lecture series not only to celebrate another milestone for this country, but to show how we can become more unified despite our differences. Tonight we've invited the Honorable Janine Geske, a former Wisconsin Supreme Court Justice, to consider this topic from a legal perspective. On September 17th, CSA's own Sister Diane Brigant will speak about unity and diversity from a theological perspective. Sister Diane is a world-renowned biblical scholar, and I have to add that when she was at the Catholic Theological Union in Chicago, one of her students was the future Pope Leo. So then on October 22nd, Alexa Merrill from Project Unite will tell us about the Dignity Index and how we can have more thoughtful and respectful conversations when we disagree with someone. So before I introduce Justice Geske, I'd like to welcome to the stage Sister Sharon Paulno, General Superior of the Congregation of Sisters of St. Agnes, who will offer a blessing for this evening.
Thank you, Jenny. We, the people, gather today still valuing the Declaration of Independence, written 250 years ago. So let us pray. God of every nation and people, from whom all blessings flow, thank you for our country and those who still believe in the values espoused in our Constitution. You have walked with your people through times of promise and trial, guiding us, calling us always closer to justice, mercy, and truth. Awaken in us a deeper reverence for the dignity of every human person. Fill our hearts with compassion for those who are marginalized or forgotten. Help us to welcome the stranger, to care for the poor and vulnerable, and to seek the common good. Deepen within us a spirit of solidarity, that we may see one another as neighbors, walking together as one human family. May all share in the blessings of this nation and live with dignity, security, and hope. Guide us to be wise stewards of the earth, our common home, that we may protect it for future generations. Send forth your Spirit upon this nation. Renew in us a spirit of humility and wisdom. Guide all people of this land to be faithful citizens, formed by conscience and committed to truth. Help us to be instruments of reconciliation in our communities and in our world. May our freedom be guided by responsibility, and our liberty be joined with justice. May this anniversary not only recall where we have been, but call us forward to become a more just, more compassionate, and more unified people. With grateful and humble hearts, we still confidently say, "In God we trust," and commit to being the people we have been called to be. Amen.
Thank you, Sister Sharon. So now I'd like to introduce our speaker for this evening. The Honorable Janine Geske served as a justice on the Wisconsin Supreme Court from 1993 to 1998 and currently serves on the Marquette University Board of Trustees. From 1998 to 2013, she was a distinguished professor of law at Marquette University Law School, where she founded and directed the school's Restorative Justice Initiative. In 2022, she returned to the law school to set up and manage the Andrews Center for Restorative Justice. In the fall of 2011, she served as a visiting professor of law at the Catholic University in Leuven, Belgium, in restorative justice at its Institute of Criminology. After earning her bachelor's and master's degrees from Beloit College and her law degree from Marquette, she became the chief staff attorney for the Legal Aid Society in Milwaukee, where she worked until 1979. She was an assistant professor at Marquette from 1978 to 1981, during which time she founded and directed the school's Clinic for the Elderly. Beginning in 1981, she served in the Milwaukee County Circuit Court for 12 years until she was appointed to the state Supreme Court by Governor Tommy Thompson in 1993. She won election to the court in 1994 and resigned from the bench in 1998. From February to May of 2002, she served as the interim county executive for Milwaukee County. And from 2002 to 2003, she served as the interim dean of the Marquette Law School. She has been a member of the faculty of the National Judicial College in Reno, Nevada, and has shared her knowledge of mediation and restorative justice with judges, lawyers, and community members around the world. So she has so many awards and honors, we can't go through them all, except I will mention that she received an honorary degree from Marian University. But all these honors and awards point to her servant leadership in the areas of peace and justice. So please join me in welcoming Justice Janine Geske.
Thank you, Jenny. Now, if my husband were here, he'd say, she just can't hold a job very long. So it's another way of looking at that resume. It's really my pleasure to be here tonight to be able to talk to you for a little bit about a very important topic, our United States Constitution, our founding principles and values and the celebration of us as a country. I want to commend the sisters for putting together this series of events because it is so important that it's more than just parades and flyovers, but in fact it's people celebrating truly the values that we have. Now, hopefully you all picked up your Constitution because I'm going to give you a quiz at the end. No, I'm just kidding. What I'm going to do tonight, and I was trying to think about how I would approach talking to you. You heard from Jenny, my passion and my work for the last 25 years has been restorative justice. So I work with survivors of crime, and I work on clergy sex abuse and victim offender dialogues and all those things. And so that's usually what I talk about. And so it was good for me to have to think about another topic and think a little bit not only historically on the principles of our country and our state, but also the role of the courts. And so what I thought I'd do tonight, I'm going to touch on a few historical facts. Most of you probably already know them. Some things may be new. And then I'm going to take you through about 4 or 5 I think significant because they set a lot cases from our Supreme Court and what the role of a state Supreme Court is vis-a-vis the United States Supreme Court, vis-a-vis the legislative and executive branches. You probably all remember from history class, because we used to learn all those things, that we began with Articles of Federation in the United States in 1787. The 13 states got together and they decided they had to put some kind of document together, primarily to deal with foreign issues. They were all wanting to be pretty independent at that point. How many of you have seen Hamilton? Okay, so some of you know a lot of this history, right? And when they originally were talking about these articles of confederation, they set it up as a weak Congress, which we're going to get back to in a while, and they didn't want an executive branch because they'd had it with the king in England, King George III, and they were not interested in having some executive overseeing the government of their states. And so the states were to remain sovereign. Well, it wasn't long until they realized that they had to do more, that was not going to sort of unite and provide the kind of guidance that they wanted. So they wound up having the Constitutional Convention, there were factions. We like to sort of think, oh, they all got together and they agreed to all these principles and separation of power, but there were a lot of factions. There's factions with the northern states, the southern states, the slave states, and the free states, and large states and small states. Some of the fights we still have going in this country. But we had incredibly gifted founders, Hamilton and Jefferson, Washington, Benjamin Franklin, James Madison, and others, who worked on trying to design this government, this constitution, this structure. And they came up with this 3-branch of government: the executive, the legislative, and the judicial, each with their own responsibilities and their own programs. And I'm going to talk a little more later about the checks and balances, because that was a fundamental part of them putting that Constitution together, is that they wanted checks on each of the other branches by the branches. When they originally designed it, they designed Congress, and Congress, of course, was going to be both the Senate and the House of Representatives. The Senate, for a long time, senators were elected by the state legislators. It was not until the early 1900s that actually the states started also electing the 2 senators from their states. But the idea was that there were these 2 houses in Congress that were going to work in tandem, each with some specific obligations, and then we would have the judicial branch, and then the executive branch, the president, the vice president, and ultimately his or her cabinet. they wound up having to have 2/3 of the state approve that Constitution, and were able to convince people that the checks and balances, the separation of powers, was going to make this really a vibrant and good government that would help protect the rights of citizens, which ultimately what they were most interested in. They had felt that they had not had those rights protected when they left their countries. It was when they were debating the Constitution, there was a lot of discussion about the Bill of Rights and the rights, what about all these individual rights? And there were promises made that after they would get the government up and going, that the first thing they were going to work on was the Bill of Rights, and they did. And you have all that in your books, but I just want to mention a few of those because they really were designed to protect the individual liberties and limit federal power. Obviously, we always talk about the freedom of speech. Everybody talks about that. But also the right to assemble and petition, the right to practice your religion, and the right of the press, the free press. There are other protections dealing with unreasonable search and seizure. Those are all terms we hear when we hear about cases that judges find things unreasonable or reasonable, and I'll get back to judicial decision-making in a while. The right to a speedy trial, the right to a trial by jury. And the power is not delegated to the federal government or reserved for the states of the people. So it was all these checks and balances, and the legislature, Congress, was to have a check over it was in control of the budget. They were the taxation entity. They had the purse strings to the country, and they would make those decisions. The executive was the administrative head, and in addition, he, and still is true, we know, is a commander of the military and appointing a cabinet and people to administer the government. And he or she, we're waiting for that she, but he has the right of, veto power over the legislature. So that's one of the many checks. So Congress had the purse strings, had making laws, taxation, regulating commerce, declaring war, and controlling national budget. Now, we hear a lot of these things these days, and I'm going to try not to get partisan and political, but I think everybody would agree that we have a president who's trying to amass as much power as he can, and Congress it looks like from the outside that they're letting him do it. There's a lot of debate. You hear it with the war in Iran, right? Whether or not we're at war or we're not at war, whether Congress ought to step in, and Congress has decided multiple times, the majority of them, not to step in and require the president to have to come before a Congress to have the war declared. I'm not going to get into the nitty-gritty of some of the President Trump's policies, but the taxation issue or the tariffs and the whole issue of tariffs, again, I'm not going to get into the politics of that, but the question is whether Congress is the one who's supposed to be doing the taxation and managing the budget and the financials. And really the desire of the founders was to make the Congress the place for the national deliberation. We're going to have all these Congress people elected by populations in the various states and the senators, and all these individually elected people were going to come together and make a lot of the policy, enact the laws. That was their role as a branch. Now the judicial branch, and we often heard this, had neither sword nor purse. They don't have any money. They have to go and beg money from the legislative branch, and they have no enforceability. And we hear that a lot, the discussion about whether the courts can enforce. And the question, because in part some of the things President Trump has said about some of the opinions, whether or not, what happens when he says, forget it, I'm not going to listen to you, Supreme Court. We haven't quite got to that yet. That will create a constitutional crisis because the expectation was that the courts would, particularly the U.S. Supreme Court, would be the final arbiter of legal-related issues. And he has, more than any other president, complained and indicated that he doesn't want to follow the decisions. And so we'll see where that goes. That is an important principle that I think we all need to fight for, that court retains the ability to make those final decisions. So the Supreme Court has multiple roles. One is to interpret laws. So when the legislature, whether it's Congress or the state legislature, enacts a law, and there's a question, and I'm going to give you an example of that in a little while, there's a question of what a word means. Sometimes you'll see that in the paper. What does "the" mean in that? Or what does 5 working days mean? Or what does it mean? And sometimes it's not clear what the legislature intended, and the court's role is to then say, this is what the legislature intended, or this is what it should be. Now, the irony of that, we used to have, some of you may remember Justice Bablich. He was on the court many years ago. He was on the court when I was on the court. He had come from the legislature. He'd been, I think, speaker, and he always would say in the room, well, of course they're ambiguous. That's how we got everybody to agree to it. Yeah, we told one side it's going to do this. We told the other side it's going to do that. And then when the court will have to finally make the decision. And there's some truth to that. You know, the language is squishy, and partly because that's the way Congress or the legislative branch gets together and gets everybody to agree to it. That doesn't make it particularly easy for the court. One of the big roles of the court, and I'm going to spend more time on this also in a few minutes, is a check on constitutionality. Whether or not laws enacted by Congress or the legislature are constitutional under the United States Constitution, and in Wisconsin under the Wisconsin Constitution. And then obviously there is the usual thing that courts do is resolve disputes, right? Handle divorces, handle criminal cases, civil fights over car accidents, and the court system is the place that those disputes are to be resolved. So I'm going to tell you about the Wisconsin Constitution. We don't talk a lot about that, but it's important because we do have our own Constitution. There was an attempt to have, well, there was a Wisconsin Constitutional Convention in 1846. That was not successful, but in 1847, they were able to obtain and write a constitution. It's been amended 150 times since then. I don't know if you've noticed on the referendums, and we've been amending it a lot in the last few years. Somehow we've had a legislature that thinks it's a good idea every time there's a problem to amend the Constitution. I'm not a great fan of that, but it is a vote. It's a vote by the people, and the people want to amend the Constitution. One of the amendments, and some of you maybe remember it, the Constitution of Wisconsin provided that the Chief Justice of the Supreme Court was the most senior member of the court. And Chief Justice Shirley Abrahamson, who was on the court when I was there, was the Chief Justice. There were people in the legislature and some on the court that did not like her. And so they decided to put forward to the public a vote to change that, and that the majority of the court would elect the Chief Justice after all these years and years of doing that. That amendment passed, and so she was taken out of that position. And it was another one of the justices was elected. When they originally set up the court system, there were only one kind of judge in Wisconsin. Now, the federal court judge, we've got federal courts that hear federal issues, and then we've got Court of Appeals, which are regional, that hear the appeals, and then we have the U.S. Supreme Court. In Wisconsin, there was one court, judges, and those judges, those few judges, were both Supreme Court justices and county judges. I mean, they heard both things. Eventually, in 1853, they decided they needed to form a Supreme Court. And so the Supreme Court of Wisconsin was created. It was a smaller number to start with, and in 1903, it expanded to 7 justices. We were just talking previously about the election of judges, and that's a whole topic if people want to ask about election of judges. You know, Wisconsin, obviously you know because you're alive and you saw all those commercials, particularly a year ago, that we elect our judges. Not every state, and actually I think it's maybe a majority of states, do not elect judges. They appoint them through various ways. And it was a debate at our constitutional convention in Wisconsin whether we should elect judges or appoint them. We have always been, everything when our government was set up, it was set up, and not in the liberal sense, but a progressive. That means giving a lot of voice to the public, having people have a lot of say. And the advocates for letting judges be elected rather than appointed were able to convince the majority that that's what we ought to have in Wisconsin. So our judges have been elected since the very beginning. And until recently, I thought it wasn't too bad a system. Unfortunately, the input of millions and millions of dollars and political issues, I think, have made it problematic, our court races. And, I don't think we're probably going to take away the elected judges, but it's become a big problem. And this last one wasn't as bad as the one before. And I'm friends with all the people that ran. It's not them individually, it's the money that gets put into the races. And the sense that the public gets a sense that you're voting on an issue. And I think for the last couple elections, if you ask most people on the street, probably not people in here because you're interested in here, but ask most people on the street, they thought they were deciding to pick a judge that would vote one way or another on abortion. And that seemed to be the ads, and that seemed to be the only issue. And of course, they or may not get a case related to abortion, but judges do so much more and have so much more work to do in terms of analyzing state statutes and everything from police action to, do our laws pass U.S. constitutional muster as well as state muster. That sort of gets lost in those campaign ads that we see. I'm just going to touch on it because you might be interested. There were, for a while, county court judges and circuit court judges. So in Fond du Lac, for example, you had county court judges and circuit court judges. The county court judges handled a lesser kind of case, and those were merged together in 1977. That was after I was practicing law, and everybody became circuit court judges. So you elect your judges in Fond du Lac, as we all do in every of the counties. And those judges, the circuit court judges, are the ones that hear, we call it the first court. They hear everything. They hear criminal, they hear civil, they hear probate, contract dispute. If someone says, I'm going to sue you, you're going to the circuit court, except in rare cases. And that's where the jury trials are. How many of you have been jurors? Okay, quite a few of you. So you know what that is. So that's a great responsibility. As a judge, I always just so admired my jurors. And, that's where all that happens. What happens, now I'm going to be very pragmatic, just in case you don't know this. Everything that's said in a courtroom is recorded. It used to be a court reporter. Now some of them are actually recorded digitally, but everything's recorded. And then if somebody loses at that court level, whether it's a jury verdict, they don't like the sentence, you don't like the decision of the judge, you have a right of appeal in Wisconsin. And the appeal is to the Court of Appeals, and there are 4 districts across our state. And those courts were created in 1977 as well. And those courts here, anybody who wants to appeal a circuit court opinion can go there. Now, those courts no longer see witnesses, they don't see police officers, they don't see exhibits. What they have are the transcripts of what happened at the trial, and then the briefs of the lawyers to make an argument. And what they are looking for is, did the trial judge create error? I always explain, they're not trying to guess again on the jury. They're trying to look at what the trial judge did, and did he or she make legal errors or other errors? And if they did, then they sometimes reverse the case and send it back for a retrial or take other action. But it's completely a paper-related appeal and not with witnesses. Then if you lose at that level, that's when you can apply to the Wisconsin Supreme Court. And it's a process much like people who lose in the federal courts go to the U.S. Supreme Court. They petition or ask the court to take the appeal. And those appeals are also on paper. They don't have witnesses, they don't have parties except when the president shows up for an argument, but generally there's nobody there other than the lawyers on the cases, and they are looking at the case below in terms of the briefs and the law. But part of their obligation is something constitutional, and that's a hard examination, right? Because, and you've heard probably debates about how judges interpret constitutionality or statutes. There's strict scrutiny, or say, what are the original founders? What did those people back at the beginning of our country, what did they mean by when they wrote those laws? Well, you could do that, but you know, it's a different world, right? And I don't know if you saw that the other day, that birthright case, the president's was at the Supreme Court, and I listened to the oral arguments, and one guy was arguing, was one of President Trump's lawyers, saying, you know, Judge, you know, 200 years have gone by, things have changed, it's a different world out there. And Chief Justice Roberts said, but it's the same Constitution. I thought, whoa. Okay, well, let's start again. But it's trying to root the opinion in the Constitution. You know, do the words of the constitutional amendment. And you've got all these issues, whether it's Roe v. Wade, you know, is that inferred into some of the amendments? You've got all those are all analysis that the courts have to do, and the Wisconsin Supreme Court does. Now, the state courts Constitution, when they look at the Wisconsin Constitution, we cannot take away any rights that the federal Constitution gives you. So you've got all your federal constitutional rights. But if our constitutional founders, our Constitution, wants to give you more rights than the feds do, the Wisconsin Constitution can do that. And there's a whole debate in the legal world is how much you should rely on state constitutions versus federal constitution. I'm going to take you in a minute into a case that dealt with that issue. I just want to point out that unlike the beginning of our judicial system, for a number of years, 6 of our 7 Supreme Court justices are women. And we've sort of held the record in Wisconsin for the last several years. So that is certainly a change of what happened a long time ago. There was a decision by one of the chief judges, his name was Ryan, in I think maybe the 1800s, maybe the early 1900s, where a woman tried to get admitted to the bar as a lawyer. And he wrote this opinion about, a woman can't hear the kinds of things we talk about in the courtroom, and it will shock her conscience. And he denied her ability to be admitted to the Wisconsin Supreme Court bar. Well, that got changed. The legislature, she went and fought through the legislature and got them to change it. And that's one of the things that I'm talking about, these branches. When the Supreme Court reaches a decision that's not a constitutional argument, but it's a statutory or some other decision, the legislature can enact a law that changes that. So if, I'm going to make this up, let's say if your neighbor throws the ball, I'm going to make this up, a ball against your house, and the Supreme Court says, you know, that's a tort, that you're going to be able to get damages for that. That's development of common law. The legislature can come in and say, nope, that's not. So they can overrule not constitutional opinions, but any other interpretation of the law. So there's that give and take, but it's not easy sometimes for the legislature to overturn things, but they do. They react to what the Supreme Court has done. All right, I'm going to give you I'm going to get this practical because I know it's a little esoteric here. 1850 brings us to a point where our Wisconsin Supreme Court played a role in deciding our Wisconsin Constitution stood for more than what the feds wanted. Some of you may have heard the story. There was a slave by the name of Joshua Glover. He was from Missouri, and he'd escaped from Missouri, and he had moved to Racine. And he'd lived there for a couple of years, and the feds, in the meantime, Congress passed a law that was the Fugitive Slave Act. And the Fugitive Slave Act required Northerners to help the slave owners recapture runaway slaves. And he, at some point, was captured by the police, and he was put in the Milwaukee County Jail. And so this is 1850, and they were going to send him back to Missouri. And there was a man by the name of Blaine, I think his name was. He was the abolitionist, Booth, Sherman Booth. And he got the crowds riled up about this idea, proud of Wisconsin, and they brought 5,000 people to the Milwaukee County Jail. Now, that's pretty impressive in 1850, to have that kind of crowd complaining that he should not be returned. And they were able to get Joshua Glover out of the jail. And they put him in the underground railroad system, and they wound up taking him to Canada. So Sherman Booth was then arrested for interfering with the Federal Fugitive Act. Let me just say this up. When you're going down to Milwaukee, when you're going to that Brewers game or going to something, you'll see there's a mural along the highway, I-43, and it's Joshua Glover. There's a painting of Joshua Glover and signifying this whole incident. But there was an argument at the Supreme Court, first for a judge and then at the Supreme Court, that our Constitution was not going to allow this to happen, and that they held that Booth should be set free, that it was a wicked and cruel enactment by the feds. It violated the Wisconsin Constitution and therefore was unenforceable in Wisconsin. So he was never convicted of that crime. It's one of our proud moments, I think, as a court and as a state, that we were able to step up to that. I'm going to give you another example of a case that it deals with First Amendment and practice, both, there's practice of religion and your faith. They're both protected. When I was on the court, there was a group of Amish from northern Wisconsin, very conservative wing, I guess you'd call it, of the Amish community up there, who did not want to put the orange triangle on the back of the buggy, which is required by state law if you have a slow-moving vehicle. And they felt it was contrary to it was gaudy, it was contrary to their religion. They got tickets, and they objected to the tickets. And that came up to our court to decide whether or not that was an interference with their faith and their religion. Now, I'm going to back up for a moment. There was another case that went to the U.S. Supreme Court right before this that involved Amish also. There was a requirement in Wisconsin that kids had to stay in school till they were 16. And the Amish community ended their education at 8th grade. And the U.S. Supreme Court held that was in interference with their practice and found that they could not be punished for holding their kids back if they wanted from those years. So when we got the case on the orange triangle, we had to come up with a test, and that's part of what the Supreme Court does, is saying, when you write a decision, it's not just going to apply to those people sitting there, it's going to apply across the board. So you have to come up with some test that judges and lawyers can use. And so the test we relied on was actually one that was used in Minnesota as well. First of all, the first question is the religious belief or practice something that is sincerely held? Now, that's not always easy, but at the trial court, they could take testimony. It's not somebody who said, my religion says I have to smoke marijuana 5 times a day, and and you have to protect me against that. They have to be able to establish that it is a seriously and sincerely held practice. Then the question is, does the state law burden that religious exercise? Well, this orange triangle did. Because they felt so strongly, they all wear black. And I have to tell you, the oral arguments, I wish I had a photograph of the oral arguments, because the Amish men came to the oral argument. And the whole back of the courtroom at the hearing room at the Supreme Court were these guys in the white shirt, the suspenders, and the long beards. And you just looked out there, and it was just an amazing sight. And they all found rides to get up to Madison to come and hear this case. Then the question is, okay, it does burden, I mean, it interferes with their religion, the Orange Triangle. Is there a compelling state interest in having this law? Because if it's not a compelling state interest, then why should you let them practice their religion? Well, there's a lot of discussion in that case, in a lot of cases, and when I was looking at this yesterday, you know, there's a lot of stuff on the internet about all the buggies that get hit, right? People that get hit, people come over a hill and run into the back of buggies. There's a lot of, and the state argued that, you know, it was really necessary for safety for them to have the orange emblem. So the fourth question is, that you ask, is what's the least restrictive means can the state meet its obligation? And the Amish came up, argued to us and showed us, in fact, I had a video that I watched that they gave us. They put white reflective tape all the way around the back of the buggy. It was actually on the top and around the back. And frankly, you could see it more than the orange triangle, because the whole back of the buggy was sort of reflective when your lights hit it. And so the Wisconsin Supreme Court was unanimous in saying that that was an interference with the First Amendment of the U.S. Constitution, the First Amendment of the Wisconsin Constitution, and that these individuals could not be ticketed for violating that provision. One of the other cases, to show you the nuances of a court, which did not involve a constitutional issue, was there was an issue before we had gay marriage was recognized, and the whole issue of gay marriage, gay adoption, gay visitation was in the courts a lot when I was on the court. And one of the issues on the visitation, there was a couple, one of the women had the child. I don't remember if she adopted the child or had the child, it didn't really matter. And then there was her partner who didn't have a legal tie to that child. And the question was, did she have a right to ask for visitation when they broke up? And the case was decided, and I was a deciding vote in that case, because the statute said that a parent, a step-parent, a grandparent, or somebody who has a child-parent type relationship has a right to visitation. So then when we were looking at that language, you say, well, the legislature, I don't know if that's what they intended, but that's what it says. And that should allow visitation. And so on a split decision, we allowed visitation. There was another statute that dealt with adoptions, and it did not have that kind of language. And we wound up at that point saying that there couldn't be gay adoptions. But I can tell you, I wrote a concurrence in that opinion, which begged the legislature to look at it. And I wrote that concurrence because I said, even though we do not find that the statute allows a gay adoption, there are so many children that are looking for homes and parents and relationships. Legislature, you ought to look at this, because it's your role to decide whether or not this is allowed. You don't allow it under the statute now. When we hear, I was mentioning earlier, some of you have probably seen, if you're watching the news at all, this thing in Virginia, this big, the redistricting that just happened. And there's a question of whether that's going to go into effect or not. And I was trying to listen, I listened to the ears of a judge, and I was listening that a judge had stopped the certification of that vote that happened either yesterday or the day before. And at least they were saying, and I haven't seen it, that the Constitution requires that there be a 90-day period of time between the time the governor, I don't know what he does, okays it or whatever, and the time it's on the ballot, and that it was not 90 days, and that's in the Virginia Constitution. Well, that judge, I don't know if it says that or not, but that judge has to decide that. He can't decide. He can't say, well, that's the will of the people. The majority of people voted for it, so the 90 days doesn't matter. That's why you're voting for judges who look at the statutes, who weigh those factors, and try to discern what the legislature intended. But they are not easy decisions. And I'm just going to end with one more case to tell you. There was a case, this is a case that I'm going to change it a little bit, that was in the court before I was there. For a while, this stuff was called palimony. It doesn't have that name anymore. But I could give you a case. Let's say there's a couple that lives together, and they've lived together for 35 years. They never got married. Maybe she even used his last name. He owned the property. She worked on the farm. She helped keep the books. They lived like a married couple, but everything was in his name. And when they got to be about 68 years old, he decided to say goodbye to her, and everything was in his name. The question is whether or not is she entitled to anything. She's not entitled to anything under a divorce law because they're not married, so there's no divorce law. And there's a diverse opinion as to whether she should get something or not. Our court, before I was there, held that you could have implied contracts, which meant that, it was implied that she would receive benefit from the work that she was doing in that relationship. It wasn't that she had a right to inherit the house, but she had a right to be able to claim something against the estate for all the years she put in. She suddenly had no health insurance or anything. The thing that makes that decision hard, and when I'd had more time, I'd turn you all into mini Supreme Courts and say, where are you going to draw the line if you're going to hold that? And there's a lot of equity to say, well, she ought to get some benefit. Well, what happens if they've only been together 5 years? What happens if they've only been together 1 year? What if they've been together 3 months? Where are you drawing the lines? Because this case has to tell everybody where the lines are. And that is finally some of the role of the courts. I am so saddened by the attacks on the judiciary that are happening at our national level, somewhat at the state, but primarily the national. These judges, and I don't care where you are philosophically on those cases, I agree with some of them, I don't agree with other ones. Those judges took an oath to uphold the Constitution, and they are doing their roles the best they can. And to be personally attacked and have their families attacked is absolutely shakes the heart of the judicial branch. I can tell you that I'm part of a big group of retired judges, particularly federal judges, who are writing all sorts of briefs and doing all sorts of things nationally, trying to lobby people on behalf of the judges, because the judges themselves can't say anything. They're ethically kept from being able to get up and say, stop it, or, that's not fair. And so, and it's coming from our highest places, those kinds of complaints, and from the other branches. And so I feel so strongly that needs to stop, and we need to really advocate against it. But here's what I'm going to leave you with tonight. So I can get burdened by what's happening, and I will tell you that I am at times. The answer to all this, and it gets a little bit into my mediation world, is we need to educate the young people. We have to excite them about this government. They have to understand it. We have to make sure civics are being taught to our kids. So many people do not understand what you understand of the role of those three branches of government and how you try to separate powers and you try to do the checks and balances. There are two places I'm going to have you look. It's the only thing I'm citing tonight. Sandra Day O'Connor, who was the first woman on the Supreme Court, has a program called iCivics, C-I-V-I-C-S. And it's programming and classes for kids on learning about the constitutional makeup of our government. The other is, and some of you knew Shirley Abrahamson. There's a wonderful website on Shirley's life. I've been part of a legacy group that have worked on it. But she has, if you have a grandchild or a nephew or a niece that's interested in this, you look for Tootsie the Goldfish, okay? Tootsie, T-O-O-T-S-I-E. Tootsie the Gold, and Shirley always taught people about the courts with Tootsie the Goldfish. And I'm going to abbreviate it. It's a whole game for kids to play. But the issue is, you've got a landlord-tenant issue, and the landlord's saying to the tenant, you have to get rid of Tootsie the Goldfish because you're not allowed to have pets. And she says, the goldfish is not a pet. And so there's this whole game for kids to play. Where do you go with that argument? You know, and how do you get into court and what happens? And it's meant for about 3rd and 4th grade level, but I did it the other night. It was kind of fun. And then you get to, all right, how do you decide if something's a pet? Well, one of the things a court will do is look to the dictionary. What's the definition of a pet? Well, it can be a domesticated animal. Well, is a goldfish domesticated? Well, there's some history to goldfish that they've been sort of trained and bred to be able to be in these little bowls. And so the whole thing, and then if you lose at the trial court, you take it to the Court of Appeals at the Supreme Court. It's really a nice way for kids to sort of look at the court system. So Tootsie the goldfish and I civics. But I'm going to stick around and answer some questions. Anything's fair game. I'll tell you if I won't answer it. But thank you very much.
Well, thank you. I don't know about the rest of you, but as soon as I get home, I'm going to look up Tootsie the goldfish.
You can forget everything else, Tootsie.
So I just want to thank Janine for sharing with us and enlightening us about how the judicial branch works in this country and in this state, and how it works with the other 2 branches of government. It was very enlightening. I appreciate that. So we have microphones set up in both aisles here. If people would like to ask any questions, feel free.
Red is on? Oh, okay.
Can you say something about what we're hearing about the shadow court with the Supreme Court?
Yeah, it's a shadow calendar. What the court has done, this is the U.S. Supreme Court. It's a very laborious process to get to the U.S. Supreme Court, and they take very few cases. Let me just do that generally. But what's been happening primarily under this administration is that, and I didn't talk about executive orders, which I could have, which I think are primarily legislative acts rather than executive orders. But the president's been issuing all these executive orders right and left, and so there are a lot of actions being filed. And the level of courts in the federal system are district court judges, Court of Appeals, Supreme Court. The district court judges are getting those cases. In a number of those cases, they've said, there's a problem with that executive order. I'm going to stay it. You can't fire those people. You can't get those records. You can't do this. You can't do that. And parties have a right to go to the Court of Appeals or try to get to the Supreme Court to get them to change that. And that's just a temporary order. It's not on the merits. But the problem with it is that the U.S. Supreme Court has started to take a lot of those. And they don't issue an opinion. They give out like a paragraph saying the stay is lifted, which means go ahead and fire them or go ahead and grab it. And so that's the complaint, that these are not, they're like not real decisions. But they are decisions because if you can fire somebody or you can grab records or you can do some of that, it's going to be pretty hard down the road to undo that. And so that's the objection. And you know, there are a number of justices who are very upset with the fact the court's been doing that. And they don't have the big debate, deliberation, oral argument, all the things you have ordinarily on a case for the court to be deliberative. It's a quick kind of everybody talk and then just kind of do it. And so I think it's a real concern. You know, what it's doing is cutting the legs out from under some of these trial court judges who are spending the time at looking at these things. And then they get this order from the Supreme Court and says, you know, you can't go ahead with this. So, any other questions? Yes.
My name is James Gray. I'm a professor at Marion University. I have 2 questions for you. As I was listening to your remarks, I was thinking about ideology that we're witnessing today and how that seems not to reflect reality. And to the extent that you're willing to comment, I'd like to get your insights and thoughts. And my second question has to do with Milwaukee County Circuit Court Judge Hannah Dugan, and that particular episode, which I believe you know all the facts, and what your view of all of that may be.
Sure. All right, ideology, that's a big question. My concern is that we are throwing out of whack all those principles in the Constitution. You know, Congress is not standing up and doing what they should do. And, you know, the whole idea is that it's this deliberative process, and sure, there's conflict and people with different opinions, but, you know, there's almost no attempts to even work cross-party or to get together. And so I'm just hopeful that, you know, we're going to hit sort of a low and then it's going to get better again, because you know, it's gotten, I mean, it's to the point we were talking about with some of the sisters at dinner, you know, people can't sit and talk to each other anymore because of the ideology. Yeah, everybody's so wed to their positions. And really, people are not even talking about the principles that underlie what's going on. I'll talk about Hannah Dugan. I'm involved in that case, you probably know. But for those of you who don't know, Judge Hannah Dugan's been a judge for a number of years, was a judge for a number of years in Milwaukee County. She is somebody that, I've said this before, if she was like this far out of joining the sisters, she is none like nobody else I know. She works with the poor, she's a great advocate for social justice. She's devoted her life to that work. That's how I would describe her. She's been a friend of mine for a long time. And she puts us all to shame with her good works and her deep faith. Okay, so I want you to give that background. She had a case in her courtroom, maybe most of you remember it, but she had a case in her courtroom where she was calling the cases, and out in the hallway was some ICE officers. And they were in plain clothes, and a public defender recognized them and took a picture of them and came in. Now, I talk to Hannah all the time. I have not asked her, so this is not her version. This is what I've read. But the public defender came in and told her that there's ICE officers out there looking for somebody in her court. She went out in her robes outside of the courtroom, told them they had to go to the chief judge's office. There's a real issue, you know, whether you could enter a building without a warrant. I mean, that's a whole other issue that we're litigating, and whether you can enter, whether they can arrest people in a courthouse, and people debate that. But anyway, she went back in the courtroom. She wound up calling the case with the individual and his lawyer. She adjourned it, and then what I know is there's a back hallway where the jurors normally go, and she showed him that door to be able to go out. And what was happening in the hallway was that I think there were like 3 or 4 agents. One of them stayed out there. The others went to the chief judge's office. When the immigrant came out with his lawyer, the ICE agent was right there, but he didn't do anything. You know, somehow they have to operate, this is my bias, in group. I don't know why they don't have individual powers. But anyway, so he rode the elevator down with them to the street, and they were speaking in Spanish, the lawyer and the client. He was meanwhile calling his colleagues to come and get them, and they wound up coming down, chasing him, and arresting the defendant. The government decided to charge Hannah Dugan with a felony for interfering with the ICE agents and obstructing justice. And it's been it's the only one nationally that's gone this far, that a judge, in carrying out her duties within a courtroom, has been prosecuted. They literally put her in handcuffs and leg irons and put her into the lockup at the federal building. Totally inexcusable. It was all for parade. Now this is my bias, but you know, it was they could get the big pictures of her, the judge, in handcuffs. Unfortunately, she went to trial and she was convicted, and the sentencing's in 2 weeks. She resigned from her judgeship because the Republican legislators were going to try to take away her pension and do all sorts of other things to her, and she'd had enough of the fight. So unfortunately, we've lost her as a judge, but I'm hoping and praying that she's treated fairly when she comes to sentencing in 2 weeks.
Thank you.
Yep. think we're good. If not, I'll be out in the lobby if anybody wants to come up. Oh, we got one more.
Okay, Barbara Lent. I think
Oh,
we know each
Barbara.
other.
Hi, Barbara.
I think we know each other.
Yeah.
Can you comment on the birthright citizenship
sure.
and what your feelings are that the Supreme Court, what's going to happen? The 1868 birthright citizenship?
That constitutional provision is clear as day, that if you are born in the United States, you get citizenship, period. That's what it says. I can't, I don't know where a couple of those justices are going to be. It was pretty clear from the questions that were asked, the ones that really angered our president, but were asked that the court was not leaning toward adopting that argument. They're really, times have changed and we're trying to get rid of immigrants and whatever else, rich China people are coming with their kids and all this nonsense. The oddity is that the conservatives on the court normally are strict, follow the rule of what does the Constitution say? We're going to follow the Constitution. What did the founders say? Well, the constitutional provision, this amendment, says if you're born in the United States, you obtain citizenship, including children of slaves. So, to me, it's a no-brainer. The court shouldn't have even taken the case, but they did. So they've surprised me badly on a number of cases, but that one, I think it's going to be clear that it could even be unanimous, but we'll see.
I have a question about a streamlining that was happening in Tucson, Arizona when I lived there for 12 years, and they considered it due process. I didn't consider it due process because of the way it was done. They would bring 80 people in at once, and yes, they would have representation, but very little representation, very little conversation. Is that not unconstitutional?
Do you want to describe a little bit better for me what it is that was happening? What were they doing?
In the Tucson court system, they would have a day that they called streamlining, where they would bring immigrants that had crossed the border into the court system.
Okay.
And I considered it not due process because they were handcuffed, they had ankle chains, they had all kinds of things. And I felt it was an abuse of power of the court system itself. And it just, to me, seemed a lack of humanity.
Well,
it was inhuman.
I'm not going to argue with your conclusion. I think you're absolutely. Was it immigration court or was it a trial court? Do you know?
They considered it immigration court, and they called it due process.
Yeah, right.
And
well,
I don't understand. Maybe I don't understand due process.
Well, you do. The immigration system is under the Department of Justice. It's not under the judicial branch. And so they hire and fire the judges, Justice Department, Attorney General Bondi, and then now whatever his name is. I'm not going to defend it. Due process, really, but they try to argue. I can tell you what some people on the other side argue, that immigrants who have crossed over unlawfully shouldn't be given rights. But our Supreme Court, U.S. Supreme Court, has said everybody who's on U.S. land is entitled to the constitutional rights that are provided. So it really shouldn't happen, but it does. But the immigration court system, I don't know if you've seen that, they've been firing judges who are allowing too many people to stay. So, it's not under the traditional judicial system, and again, it's part of to me, it's almost corruption of the whole Justice Department. They've gotten rid of anybody who has any strong ethical feelings about this stuff. I absolutely agree. I abhor the wearing of the masks by the ICE officers and grabbing people out of houses. I mean, that's another thing that I think violates the Constitution. We have a lot of that going on right now, and that's why we need all branches of our government to stand up and to work hard, and for you to encourage people that represent you at all those levels to make sure that they remember what our founding documents said and what we believe in. You know, I was thinking the other day, if we were to suddenly gather now as a country and say, let's talk about what constitution we'd like, I don't think we'd ever get to an agreement, you know, which is really a sad statement. But I'm hoping with the, you know, you talk to younger people, talk to the college kids, you talk to younger people running for office. We got to encourage them, we got to educate them, and we got to support them as they try to return us back to those principles and values that we so hold dear. Okay.
Good evening. I want to thank you for all the work you've done on restorative justice. It's really inspiring. And I have a question I think somewhat related to that. It's hard for me to understand why the United States, with our great Constitution and all of the good things about this country, incarcerates more people than any other country or most countries in the world. So I wonder if you could speak on that a little bit, and maybe if you have any advice for the future to change that or make things better, I'd love to hear it.
Sure, I could do that in 30 seconds. No, I'm just kidding. Our incarceration system is a big problem. And we keep doing the same thing over and over again, and it doesn't work, you know, rather than trying to figure out what other countries have done. I'm going to tell you an encouraging story before I answer your question. I got to tell you one restorative justice story just because. So when I was a judge in circuit court, I had a case, a murder case. I sat in homicide court. A 14-year-old kid that had shot and killed another young kid on the street and shot the girlfriend. He shot and killed the guy because the kid's hat was tipped the wrong way, and he thought he was a member of an opposing gang. And so he was waived into adult court at age 14 and charged with first-degree murder and attempted first-degree murder. And I was having a sentence, and he's a kid, right? He's 14, but you know, and as a judge, I can tell you that as a whole nother lecture, you could have me come talk about sentencing. You know, I got to think about the public. I got to think about what's this kid going to be when he gets out? What if he gets out when he's 28? Is he going to kill more people? You know, what's inside him? And, you know, and there's lots of things that go through one's head as a judge, and particularly a case of a 14-year-old. And I gave him a pretty significant parole eligibility date because it was going to get life imprisonment because of the homicide, but it was the date he'd be first up for parole. And anyway, he went off, and through the years, I think about him and wondered what happened to him. And I was teaching in Green Bay Correctional and Fox Lake, and I tried to look him up, but I couldn't remember his name. And I think, I wonder what happened to that kid. And then we were learning a lot about adolescent brain development, and you know, that 14-year-old's brain isn't developed. And I'm thinking, oh, maybe I should have known that. You know, so I literally thought about him more than almost any other defendant through a bunch of years. Anyway, about a year and a half ago, I got a call from a philosophy professor at Marquette saying they have a class at Marquette where they're teaching returning citizens. Those are men and women coming out of prison. And she said, there's somebody in my class who would like to talk to you. And I said, oh, that's fine. So we wound up meeting and had lunch, and I had with the professor and him. And I met him, and he told me his name, and I said, you know, I don't remember you. That's probably a good thing, you know, because I remember some of the, you know, terrible ones. And we wound up having lunch, and we're talking, and he's currently employed by the Medical College of Wisconsin as a violence interrupter. And the violence interrupters of Milwaukee are men and women, often with criminal backgrounds, who are called to a shooting or a gang fight or trouble by the police department to calm everybody down. They talk to the kids, they talk to the families, they talk about revenge, they got street credibility, and so, as he tells me, they're the only ones without guns on them. The family has guns, the cops have guns, everybody has guns. They have no guns. And he's been doing that for about 5 years, and I'm thinking, oh, it's really great work and everything, and I thought, why does he want to talk to me? And he starts talking, and then he starts talking about the fact that I sentenced him, and I thought, oh, huh. And then he talks about he was in sentence. Well, anyway, we get to a point where he talks about that he was a juvenile, and all of a sudden the light bulb went on, and I said, the hat tipped the wrong way, and he said, that was my case. This guy is working at Medical College of Wisconsin, is buying a house, is doing great things. He's in his 40s. He's doing incredible work. We've become very friendly, I guess is the best way to describe it. He's presented a number of my programs. I tell that story because we're not very good at predicting what a 14-year-old is going to be like when he's 40 years old. And not to say that all of them turn out like that, or even most of them. But I think we have to keep looking for alternatives. Victims aren't happy with the system either. And I work primarily with survivors of violent crime. And, you know, courts are trying to do things. There are what I call healing courts. There are alcohol treatment courts. In Milwaukee, there's some well children courts where there may be abuse of kids, and they bring mothers and psychologists together and try to support people, and the judge meets with them. And there's a lot more, you know, what I used to think of as sort of social work kind of stuff, but being built into the court system. And we need to do more of that because, you know, you have people with drug problems, they just come in through. And it used to be, when I was first a judge, it was people with alcohol problems, right? They'd be drunk, they'd be put in the jail, they'd spend 2-3 nights, they'd come in front of the court, you'd say time served, you put them back out in the street, they go get drunk again. I mean, it was nuts, you know, and so it's, you know, it's the old thing about you don't just keep doing the thing that keeps failing. So I think the answer is to keep finding creative things to do, particularly with kids, as alternatives to bring home the importance of them being contributing members of the community. Thank you.
Thank you. So I just want to thank Janine again for her candor in answering these questions tonight. So we have a reception outside for you, and there are 2 tables set up on your left as you walk out of the auditorium. If you're interested in having a circle conversation, so it's a little more intense conversation about what you heard tonight, you're welcome to join any of those circles. So otherwise, just enjoy the rest of the evening, and thank you once again to Janine.